Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney. And today we are going to be looking at your comments and your questions in the community tab of our YouTube channel. And this is the show that we are now calling Comment Counsel, because it's your comments and I'm the counsel or the counselor. And here we go. So the first one I see is from Exodus, and it says, I was hit by a 2 truck as an Uber passenger. I did physical therapy and RFA, which is radio frequency ablation, already. I'm scheduled to have a disc replacement surgery on my L5-S1. I hope to get at least $500,000 take home if possible. Right, so that sounds like fairly reasonable, right? So if he's trying to get $500,000 for himself, that means after legal fees, right? So if the case, let's say, settled for $1 million, the lawyer would take $300,000. It would be about 700, a little less than 700, like 666,000 for the client. But you might have liens to pay back the doctor for the surgery, which could be about 100,000, right? So that would make close to 500 or a little over 500 for the client. So you need $1 million settlement to do that. But it's possible if he has a disc replacement surgery. That's the big ticket item that can make it worth $1 million. Because if it's just radio frequency ablation, I would say it's worth, more like a few $100,000, maybe 150, 200,000. If it's just physical therapy, it's even less than that, maybe 20,000. So that's what's going to make it bigger. But yeah, like I said before, like the key thing is, you want to find out how much insurance that truck has that hit you. You want to establish liability. You want to make your trucking demands. Like we send out trucking demands that are specific to tractor trailer cases and they're like very detailed. There's 100 different items, or sometimes even more than 100 things that we ask for. Then you have to follow up to make sure they actually give it to you in a meaningful way, in a substantive way. Because a lot of times they'll just say objection, or we don't have it at this time, or some kind of nonsense just to skirt around the issue. But you have to follow up. Otherwise, it just becomes a dead issue and you can't use it then at trial. But you want to get that, like bills of lading, driver qualification files. Now a lot of the trucks are using like telematics, like GPS. And so you want to get that data, and then you show that data to your expert. There's a black box. There's a lot of different things you could do with trucks. Okay, and then user VZ says, I need your help. I have a complicated case of workers' comp, third-party plates and screws in the foot on Social Security Administration because of injury, needing a consultation case in settlement. It's been 2 years. I'm in Texas, but want to know about third-party case. Sure, so the best thing to do if you want a consultation is just to text me. It's 347-566-9595. Include your name, your city, your date of incident, your facts, really briefly. Like, for example, I was hit by a car, I fell in a hole, whatever happened, just 1 or 2 sentences. Your injury also, like this person said, right, like plates and screws in my foot, just a little bit, like 1 or 2 sentences. And then what we'll do is we'll schedule it. You tell me a few days and times that work for you, like maybe 1 or 2, and then I try to make myself available. In fact, I'm doing, I think, 3 or 4 tomorrow. So, and that makes it easy. Don't text me like, a whole, novel. Some people start texting me. I don't have time to read it. And also it's hard for me to parse it and then, put it together in a comprehensible form. So it's just better to be short like that. Those are, I think, from doing a lot of consults, those are really the only things I need, because it gives me a sense of what happened, where you are, who you are, and when you're available. And then we could do the chat. And then during the chat, we could, of course, do a deeper dive. And then if we need documents, you could email them to me, and I can follow up with you. And I always tell people at the end of the consult that, I hope you're going to feel better. I wish you all the best of health, but also, I'll make myself available for you. If you have another question, just text me. I never just do a consult and forget about someone. So, so yeah, I'm happy to help with that. And then Chase says, I was rear-ended by a rider truck leased by a moving company, stopped at a red light in the left lane in New York City. I had 4 surgeries, and 4 years later, my case is still going on. Plus the driver that was in the car with me passed away after the accident. Oh, I'm sorry to hear that. That's crazy. Yeah, again, the best thing to do, is just to text me, and then I'm happy to do. It's free, and it's confidential, and it's a consultation. Why not take advantage of it? And then the other thing with that is like, with New York City, if you give me your full name, I could actually look up the case in the court's computer. There's the New York State Civil Electronic Filing, and there's also e-law. So I can go on either of those and take a look at all the documents, and then maybe by looking at the documents, I can then give you some input about what's happening with your case, more detailed input. Because sometimes, just looking at that, you see certain red flags. Like there was one last week that I looked at, and there was like no activity on a case since like June of last year, of 24. And it didn't make sense. The lawyer was saying, I forgot, the client thought the lawyer told him that there was no activity for some reason because the defendants were trying to figure out like who's going to indemnify who, but that doesn't preclude you as the plaintiff's attorney from just pushing the case, getting a preliminary conference, because it was actually a construction accident, and under the law, the general contractor and the landlord of this job site, which in that case was the city of New York, are absolutely liable under the labor law. So why would you wait for the other defendants to figure out who's going to indemnify who? Well, what's the difference? Just move it forward, because basically they lost a year already. So yeah, just crazy stuff like that. So you want to be able to have somebody who's like an expert look at and see what's happening, because sometimes these cases are just not being prosecuted, and that's dangerous. Okay, and then Slip says, I have severe post-concussion syndrome 6 months after my injury. The headaches and head pressure are extremely painful. That's just one of my almost dozen injuries I sustained in a fall on ice. Oh, I'm sorry to hear that. Yeah, I think we're going to do a consult with him too. I think he texted me, so we're going to do a consult soon. Yeah, I'm sorry to hear that. That's terrible. I mean, the head injuries are actually one of the biggest injuries there are. That's why, they also command like substantial money. Like there was a case earlier this year where I think the verdict with interest was like 34 million, and it was considered a mild traumatic brain injury where the head actually was inside a car hit by a truck. So it was just like a whiplash type injury, like coup, counter coup, but it wasn't, the head never hit anything, didn't hit the dashboard, didn't hit the window. It was just like going forward and then going back, and it was a $34 million verdict, and it was actually paid. So, and then I did one in New York. It was, pretty, smaller than that, but it was 3.1 million we settled. So yeah, I mean, the head injuries are good cases for sure. And also it's a serious, life-changing, forever injury. I mean, it really is. Okay, and then Mike says, hello, sir. Last month, while riding my bicycle, I was hit head on by a wealthy business owner. 100% his fault. Tibia, plateau fracture, torn meniscus. I'm also very wealthy. Do wealthy victims always attempt to settle for more, since they are used to large numbers and think they are worth more? I mean, not really. I've never really seen that. Like, basically, I think if you're dealing with lost wages, well, obviously, right? Because if you lost your salary and you're wealthy, you're making, let's say, $1 million a year, and someone else is making like $30,000 a year, well, obviously your salary is worth more than the other guy, right? So you're going to get that. But in terms of like non-economic damages like pain and suffering, I wouldn't say that wealthy people's pain and suffering is worth more. It might be the same. It might actually turn somebody off, right? Because the jurors are not going to be wealthy. They're just going to be people from your community, usually simple people. So if they hear somebody who's a little bit like pretentious or wealthy or thinking like, oh, I deserve more because I'm wealthy, then they might actually be turned off. Or they could think, well, you know what? You don't need the money. Why do I have to sign a verdict and give you millions of dollars if you already have it, right? So just go pound ice or whatever, go pound sand. So, it could work both ways. So I wouldn't really like flaunt any kind of wealth. I think you want to be more simple. You want to be like open. You want to be friendly to everybody. But yeah, so that's what I think. And then Anjanya says, I can't seem to get my attorney to give me intensive medical care. They only wanted to inject or cut. I opted out for decompression, but would like my shoulder x-rayed. It's hurt for over a year. That's weird though, but why does your attorney have to give you medical care? You can't just go to the doctor on your own? Like, the doctor has to give you medical care. The attorney could help coordinate it to an extent, depending on where you are. In New York, we don't really, I mean, clients can go anywhere they want. It's like we could help them if they need help, but the attorney obviously can't give you medical care because he's not a doctor, So, but I guess maybe in some states, the attorney is more involved in medical care because of the way the system is set up, depending on the type of case. But yeah, I could see that's not right. You want to be able to get your shoulder checked out. It's been a year and you're in pain. Tax fact says, in 2023, I was an Uber passenger in a 3-car accident. The Uber driver signed a ticket as the at fault. I had epidural shots, radiofrequency ablation injections, and the doctor suggested I have a discectomy surgery. The Uber lawyers contacted my lawyer with a $60K offer. My lawyer and I didn't respond. We had a deposition in March. Immediately after the deposition, they wanted to mediate. My lawyer filed for a motion for summary judgment because the driver admitted to causing the 3-car accident during deposition, and it was rescheduled, and then pretrial is next week, and he's wondering if he should let this go to trial. But he was told by many different law firms that this is a slam dunk and a big trial. Mediation is next month, and I'm not sure if I should reject their offers, especially if lowballed. Well, the thing is, you have to see how much insurance they have, right? Uber, if you're suing Uber, usually they have a lot. It could be like even $1 million. But you want to find out like what they have, and then how much of what they have are they offering you. If it's only $60K and they have $1 million, well, obviously there's room to get more, either through mediation, negotiation, pretrial, or trial, because there's like $940 left on the table, right? But if it's a smaller policy for whatever reason, maybe Uber's not at fault, maybe the other car's at fault, and they only have 100 and they're giving you 60 out of 100, then maybe you could negotiate it to like 80, 85, and save yourself, because if you go to trial, you're going to pay the doctors. They're going to charge probably, at least 5, 10K each, and you might have 2. So then if you pay 20, even if you get the 100, you're only getting 80, right? Because you spend 20 on the doctors. So, it just depends. I would speak to your lawyer about that and see what kind of strategy they are preparing and how they're preparing for trial, and let them guide you, really. That's why, that's why you hire the lawyer, right? So you have to have confidence in them. If you hadn't had the big surgery, it's probably worth a few $100,000. It's probably not like a huge case. That's very common. That's like, you're describing thousands and thousands of cases just that I've seen here in New York. I'm sure there's, basically it's a case with a soft tissue injury that had a little pain management. That's considered pain management. All this stuff like epidural injections, even if you have a percutaneous discectomy surgery, that's pain management. Radiofrequency ablation is pain management. So it's basically a pain management case. So yeah, pain management cases, I mean, they can go, I did one, I got like 550, but that's a good number. Usually they settle for like, 100, 150, 200, 300. So in that ballpark. So yeah, you could do well with that. I don't know where you are, but depending on the venue. And then Smoking says, need some help with some questions I got. So here's what happened. I got a burger at McDonald's this Sunday, and there was some piece of wood, one which got stuck in an infected cavity. Now I've gone to the ER and then made the report, and today I got a call that I'll be hearing from an insurance adjuster, whatever that means. Yeah, so probably they just set up a claim, basically you reported a claim, right? You want to sue them or get them to pay you money. That's known as a claim. So they're going to assign someone to handle the claim. That's all it means, So yeah, depending on your injury, if you just had to go to the hospital once and it got a little infected, they give you like a shot or some penicillin and it goes away. You just settle with them on your own, get like them to give you, I don't know, $1,000 or whatever they're going to give you. But, I don't think it's worth getting a lawyer over. If it's something like, horrific that happens. Like I had one guy who also got infected like that by a dentist, but he ended up having like a brain injury, and the infection really spread, and we litigated, and that one settled, into the millions. If it's something like that, but you don't want that. Hopefully it's just since it happened, you said just last Saturday or whatever, last Sunday, it's going to get, the doctors know about it now. They're probably going to be able to cure it quickly. So that's better for you. You want to keep your health, get a little bit of money, but have your health. That's better than getting a lot of money and getting really messed up for life, And then Latoro says, hello, what changes when the insurance company hires a defense attorney team? Thank you. So it's just part of the lawsuit process. So basically, they're only going to hire a defense attorney because you filed a lawsuit usually. So when you file the lawsuit, they hire the defense attorney. The defense attorney appears in the lawsuit, answers It's called an answer. Answers your lawsuit. You filed a complaint, they file an answer. But really what they're doing is they're appearing in the case. So now they're in the case. So now you have both sides in the case. That's known as issue joinder, right? Because it's that's what they call it in law. Like they joinder. Everyone's in the case. Now everyone's in the case. Go see the judge, and the judge will make a scheduling order, and then you start discovery, and then after that you'll have a trial. So it's pretty much just part of the process. And then Malachi says, love your videos about slip and trip and falls, but I noticed you lawyers, I never see a video about people slipping or tripping off uneven sidewalks or curbs. It's always about snow or rain or the floor is wet. Can you do a video about that? And also if a person slips and falls and bumps his or her forehead on premise and ends up with a huge bump on their forehead and it's bleeding and need stitches and re-injured their hernia disc, how huge is that case? So if they bump their forehead and it's bleeding, well, I mean, like you have to get more of a diagnosis. Like if they have a brain injury, that would be a huge case. If they just bump their forehead and it's like they need a stitch and then, you know, the stitches just dissolve on their own and the bump goes away, it's like a boo-boo, you know. And if there's no injury, then it's not a huge case. Why would it be a huge case? I mean, if it re-injured a herniated disc, like in your neck, and then you needed surgery, then it could be a huge case. So, you know, it's pretty much like common sense. But in terms of what you're saying, what caused the trip, whether it's like water or an uneven sidewalk, I think I've done a lot of videos about that actually. It just, it's actually easier, right? Because water is a transient condition. So you'd have to prove notice of the water, meaning somebody complained about the water, somebody saw the water like hours before to show the water existed for hours. And then you can make the argument, well, the store or wherever it happened, the landlord of the building, well, since it existed for hours, the puddle, they should have found it and they should have fixed it, right? But it's hard to do if you're the only one who was there and you don't have any witnesses. How are you going to prove that it existed for hours before? So then if you can't do that, you can get your case dismissed. Unless you could show like actual notice that somebody complained. Constructive is just that you saw it and it existed for hours before you fell. And then the third way is caused and created, meaning the super was like mopping and he created the puddle, so then he's the one who created the danger, right? If you create the danger, you don't need to then also show notice because you created the danger. So yeah, it makes sense, right? Those are the three ways. But if you have like let's say an uneven sidewalk, well, now you're talking about concrete. So just snap a picture of it. And there's case law here in New York that a photo standing alone is sufficient to show notice because, like, say you have a sidewalk flag, right? It's concrete and it's higher than another sidewalk flag that's next to it. And it's like an inch, difference, elevation. Well, that's not something that happened like 10 seconds ago, right? That's probably been there for like 6 months or a year or maybe 3 years. So the photo standing alone is sufficient to give them notice because then it existed, so they should have seen it. It's their building, right? They should have fixed it. So it's really simple. It's actually, those cases are easier. And in New York, we have 7-210, which puts the burden and the liability on the adjoining landlord. So basically, like the landlord, whatever's the sidewalk in front of your property, you're responsible for it. If it's a curb, then it's the city. You got to sue the city. That's a little longer. But if it's a sidewalk, you just sue the landlord, and it's really simple. And then you have that, just take a photo of it. That's all you need. So they're pretty good cases. And then CC says, show me a truck driver without lower back issues. This is another case of someone looking for a payday. And she's responding to my video, truck driver ceiling collapse. And then someone else responded to this CC person saying, what if someone says that about you and your injuries? That's just not fair to assume. That's what the insurance company wants to say, right? They want to say everybody's out there looking for the lawsuit lottery, right? Because everybody's just a crook and no one's hurt and everyone's just everything's degenerative, meaning like, it's the normal painless aging process. And then the fact that, we hit you with our truck that weighs 70,000 pounds, well, that didn't hurt you. It's just like the fact that you lived your life up to this point, however old you are, 39, 49, 58, that's what hurt you, living life. And then the fact that we were negligent and we crashed the 70,000 pound truck into you didn't hurt you, but now you're trying to claim the lawsuit lottery and win against us. And we don't want to pay anything. So, it's whoever you believe, but that's their thing that they say. And then Latoro says, I was involved in an Uber accident as a passenger and my legal assistant told me the insurance is already paying some medical expenses and I'm still waiting to file a deposition. Why does this happen? They pay the medical bills first? Yeah, I mean, they'll pay the medical bills depending on like where you are. Like in New York, they'll pay all your medical bills up to $50,000. It's automatic. That's the no-fault law. That's the PIP, the personal injury protection. So that's why they have that, right? So the car that you're sitting in, let's say you're sitting in a car and you have, like, for example, Allstate, and then another car hits you in the rear, and that car is, let's say, Geico. Well, it's your insurance for your car. Like Allstate will pay all your medical treatment up to $50,000. But then because you get that benefit, you can't sue Geico for bodily injury unless you can show a serious injury. And then it gets complicated. There are like 9 different categories. So, you know, that's New York, but every state has their own rules about that. Please like and subscribe to our channel. Let us know what questions you have. If you leave a comment on our channel about a video, you see we go through the comments and we analyze them and we respond. So we could answer your question in one of these videos, in a comment counsel video. Or you could also text me. That's even better because then we could chat, you know, back and forth live. And then we could actually get to the bottom of what your case is about, and I could find out, because it's, you know, I don't get enough information from these YouTube comments to really understand everything to give you enough of an answer. So it's always better to do a consult. Okay, everyone, have a great day. Thank you so much. And we are here for you. Our goal is helping serious injury victims and families. Have a great day. Bye-bye.